that better, but the statute does permit a springing power of attorney. And a springing power of attorney does not become effective. It springs into effectiveness upon your incapacity. So in order to use a springing power of attorney, you would have to have affidavits and certificates of doctors showing that it sprang into effectiveness. And these are extra hoops that your agent would have to jump through at the time they're going to use the power of attorney. And things are hard enough at that time anyway, and generally we would like to keep our clients from having to jump through any extra hoops they don't have to. We do provide a procedure to our clients to try to get a hybrid. We will offer to hang on to the original document if the client wants us to, and we won't give it to the agent until we make a reasonable determination that we think you're incapacitated, that that's the limit of our undertaking. We would then give it to the agent. So that's kind of designed to try to achieve the benefits of both ways, because once we give it to the agent, then they don't have to jump through those hoops anymore. Way too much talking about power of attorney for the stuff we need to cover today. Healthcare surrogate is similar. The power of attorney is generally for your finances. A lot of attorneys combine both of these things into one document. I prefer to use separate ones. Hold over from we charge by the page. No, not really. Because in some families, you know, you might have one child that would want to be the agent for financial assets, and a different child you might want to be your surrogate for making health care decisions when you are incapacitated. And the healthcare surrogate, just by its nature, is a springer, because you're going to be in the healthcare environment at that time, and your doctor's going to know whether you're capable of making your own decisions or not, and then the healthcare surrogate would make them for you if you're not capable of making them. Your living will is an extension of the healthcare surrogate. That's your final healthcare decision, and basically says if your death is imminent and there's no reasonable medical prospect of recovery, that you don't want extraordinary procedures that serve no real purpose other than to prolong your dying. It is not a do not resuscitate order. A do not resuscitate order is actually a physician's order, and it's not good until the physician signs it. Occasionally we help our clients complete DNRs, but then they have to take them to their doctor to make them effective. And usually we don't do DNRs except in a situation where a client has an advanced terminal condition or they're extremely elderly. And let's see here. Trouble with I love you wills. You know, a lot of our clients are going to have I love you wills, which to me means I leave everything to the world's loveliest office administrator. That's not always good, especially when we get into an elder law concept or a long-term care planning concept. And I'll talk about some strategies there. But many times we're going to want to have a will that sets up a special needs trust for our beneficiaries. A trust that will take care of our beneficiaries, yet will not be viewed as an available resource to keep them from qualifying for needs-based programs. And then sometimes we use IREV trusts, and one thing that'll be obvious as we go through here, it's hard to sequence these slides, and some of these concepts slide back and forth, and we have to build a little bit of a base to be able to understand these things. But many times, and there's other attorneys in town that do seminars on revocable living trust. And those are fine devices, and they're probate avoidance and guardianship avoidance, but they do nothing for asset protection or long-term care planning or taxes for that matter. And IREV trust, we might use these in an advanced planning scenario. As we'll get into later, Medicaid, for example, has a 5-year look-back period. Under certain circumstances, we might want to put all the assets into an IREV trust, and so that after the expiration of 5 years, that trust would no longer be an available resource to prevent somebody from qualifying for a needs-based program. part of the purpose of this slide is that nursing home care is very expensive, and not 100% sure of the statistics, but the one thing I wanted to point out is that out-of-pocket number of 28% there. I'm not sure what the percentage is now, but part of the point is that it's a lot higher percentage than you might think. You know, you might think that Medicare, Medicaid, and long-term care insurance pay a high proportion of long-term care. And it's not as high as you think. And I'm not even sure how these numbers came up. I mean, do these give credit for the fact that a caregiver is missing wages because they're home taking care? And do they cover all the out-of-pocket expenses that a caregiver gives? In this country, I think it is a quite high percentage of care is actually provided from private funds. The other thing I wanted to talk about here a little bit, you know, we talk about nursing home care can cost more than $75,000. As we talk about the rest of the slides on here, if we keep a concept in mind about the continuum of care, you know, we have a life progress where hopefully we're always going to stay in the level where we can stay at home and take care of ourselves and we don't need any assistance. But sometimes our health does not hold up and we decline up to the point where we need some extra help at home. The next step may be we need to go to an assisted living facility. We may need an assisted living facility with a secure memory care unit. And then finally, we may need a skilled nursing facility. A lot of times when we're thinking about the planning and we're thinking about these various sources of government benefits that help us pay for that, keep in the back of your mind the stage we are at in that continuum of care, because the benefits are different, the way we qualify for them are a little bit different, but I'll try to bring that back to the surface as we talk about the other these various programs. Another thing I want to insert before I forget it is, as we get talking into these various sources of government assistance, oftentimes we'll talk about trying to transfer assets, trying to put assets into irrevocable trust, and so on and so forth to get a person qualified for Medicaid or veterans benefits earlier. Please keep in mind that the purpose of doing this is not to protect the inheritance.